Hi, and welcome to What's the Tea in L&E. I'm Leah, and I am here with my amazing colleague, Patrick Bolling. Thank you for joining us, Patrick. Unfortunately, my former co-host, Emily, has taken a position elsewhere, but the exciting news is that you guys will get to see and hear from many of my other amazing colleagues. And I wanted to have Patrick on today because Patrick focuses a lot on managing or helping employers with unions or helping employers without unions, explain that to us, navigate through union campaigning and what it means to kind of deal with collective bargaining. So Patrick, how does an employer stumble into having a union?
Okay, so the first thing you need to know is that the National Labor Relations Act, which protects the right to organize, engage in protected concerted activity in the workplace, applies to you as an employer whether or not you actually have a union. And so I often have clients who call me surprised that they've received a charge of discrimination or some other charge from the National Labor Relations Board when they don't have a union. So what you need to know is that there was a change in the law back probably 3-4 years ago that made it easier than ever for unions to organize your workplace. It used to be that if a union was going to organize in your workplace, they would need to file a petition. There would be a period of time where the union and the company would campaign for votes. The company would typically be campaigning for no votes on the union election, and the union, of course, would be campaigning for yes votes. But now, under a recent board case called the CIMEX case, if a union is trying to organize your workplace, they can just give you a demand, a verbal demand. They can,
what does that look like? Give me an example of what a demand looks like.
Well, it could be written, or it could be that one day an employee just comes into a supervisor's office and says, look, I've got the support of the majority of the workforce for a union, and so we are now demanding bargaining. And if you get
Do they have to use any sort of magic words?
No, just it'd be something like that. I've got a majority of the workforce that is organized, and we want to bargain.
What about, I had a client call recently, and they had 4 employees at a work site that were, 2 of them were called in for a random drug test, and they convinced the other 2 employees at this particular work site to not come in. And so all 4 of them, and this work site only had 5 total employees, 4 of them decided they weren't going to show up to work until the company withdrew the obligation for random drug testing. Would that be enough? Where they're kind of like acting together and they're saying like, we demand that you change this policy. Is that enough?
That would be enough. Yeah, in fact, it doesn't even take more than 2 people. There could be one person who's lobbying on behalf of other employees for a change in their working conditions to be protected concerted activity in the workplace. And the important thing about a demand for bargaining under the CIMEX case is that once that demand is made, you only have 14 days to file an objection and to contest that union. And if you don't, then you automatically have a union.
So what does this mean? How does an employer make sure that managers know, hey, if an employee comes to you and says, hey, we demand a union or we want these changes, what if a manager is just like, okay, cool, go back to work? Like, how do we get a manager to take that next step to make sure the company goes and actively files that petition or objection?
Your frontline supervisors have to know that if this sort of demand is made, then they need to get with HR, they need to get with company leadership, because an immediate response is required. And if they don't, then you could end up with a union without even really realizing what's happening.
Awesome. Well, do not stumble into a union. Thanks for joining us on What's the Tea. Until next time.